There are cases that end too cleanly, not because justice was served, not because the evidence was overwhelming, but because someone somewhere decided that the public version was enough. This is one of those cases. What you're about to hear wasn't buried by accident. The timeline was too precise, the omissions were too consistent, and the people who could have asked the right questions didn't. By the time you finish watching this, you're going to understand something that most people never got the chance to consider. Not because the information didn't exist, but because it was never put together in a way that was meant to be seen. Until now. In the summer of 2019, a mid-level compliance officer at a mid-sized financial services firm in New York City submitted an internal report that should have changed everything. His name was Daniel Mercer, 37 years old, a decade of experience in financial regulation. He wasn't a whistleblower by nature. He was, by every account from colleagues who worked with him, someone who believed in working within the system. He followed procedure. He documented everything. He didn't make waves, which is exactly why what happened to his report is so difficult to explain away. The report, 41 pages, formatted according to internal compliance standards, cross-referenced with external regulatory guidelines, outlined what Mercer had identified as a systematic pattern of misreported risk exposure across 3 separate investment portfolios. Not a rounding error, not a clerical inconsistency, a pattern, repeated, documented, traceable. He filed it through proper channels on July 14, 2019. The firm's internal compliance review committee was supposed to respond within 30 business days. They didn't. At 60 days, Mercer followed up with a written inquiry, which the record shows was received. There was no response. At 90 days, he escalated, again in writing, again documented, to the firm's chief compliance officer. And that's where the trail gets strange. Because what happened next wasn't a rejection. It wasn't a formal review process. It wasn't even a meeting. What happened was silence. Institutional, organized, deliberate silence. And when Mercer finally pushed hard enough that silence was no longer an option, the firm didn't address the report. They addressed Mercer. To understand what came next, you have to understand the environment he was operating in. The financial services industry in 2019 was publicly under more scrutiny than at any point since the 2008 financial crisis. Regulators had expanded their oversight frameworks. Compliance departments had grown. The public narrative, pushed heavily by industry groups, lobbyists, and a steady stream of press releases, was that the lessons of 2008 had been learned, that the guardrails were in place, that the systems were working. That was the official story. And to most people, investors, regulators at the surface level, journalists covering quarterly earnings, it looked credible. It was presented with enough technical detail, enough institutional language, enough apparent seriousness that questioning it felt almost paranoid. But Daniel Mercer wasn't looking at the press releases. He was looking at the data. And the data said something very different. The 3 portfolios he had flagged weren't obscure. They were significant. Combined, they represented exposure in the range of what internal documents, which Mercer retained copies of, a detail that would become critically important later, described as non-standard leverage positioning. A phrase that, in the language of financial compliance, can mean a lot of things. But in the context of his report, in the context of the numbers he had pulled and cross-referenced, it meant something specific. It meant that the risk these portfolios actually carried was not what was being reported to the institutions that needed to know. Not to the internal oversight board, not to the external auditors. And this is the part that Mercer himself underlined in his original documentation, not to the regulatory bodies that had a legal right to that information. This wasn't a gray area. There was a legal disclosure framework in place. There were specific reporting requirements. And those requirements, according to Mercer's analysis, were not being met. That was the official story's first crack. Now, here's where something doesn't add up. When a compliance officer files a report of this nature, especially one as detailed and cross-referenced as Mercer's, there is a legal obligation on the part of the institution to respond. This isn't a guideline. This isn't a best practice. It's a codified requirement with documented timelines and escalation procedures built into the regulatory framework. The firm knew this. Their legal team knew this. Their chief compliance officer, a woman named Patricia Orwell, who had spent 20 years in financial regulatory work before joining the firm in 2016, absolutely knew this. And yet the response to Mercer's report at every level was delay, deflection, and eventually something that looked, from the outside, remarkably like erasure. Here's what the internal records show, and these are records that were later obtained through a combination of litigation discovery and a Freedom of Information request that took nearly 2 years to process. Mercer's original report was received by the Compliance Review Committee on July 14, 2019. This is confirmed by an automated internal timestamp in the firm's document management system. The receipt is on record. The document exists. But in the firm's official compliance log, the document that tracks all reports, their status, their assigned reviewers, and their resolution, Mercer's report does not appear. It was received. It was logged in the document system. And then it simply does not appear in the official compliance record. That absence is not a technical glitch. Document management systems at firms of this size don't misplace compliance filings. The filing protocols are redundant precisely because these records matter. The absence of Mercer's report from the official log is not something that happens by accident. But let's follow the official explanation, because there was one. When this discrepancy was raised, much later in the context of a broader inquiry, the firm's legal team characterized it as an administrative error. A miscategorization. The report, they said, had been logged under a different classification code, which had caused it to be routed outside the standard compliance review process. A miscategorization. 41 pages, cross-referenced, filed by an experienced compliance officer through the proper channels, miscategorized. That explanation was accepted without further examination. The inquiry moved on. And that might be the most disturbing detail in this entire case. By November 2019, 4 months after he had filed his original report and received nothing but institutional silence, Daniel Mercer made a decision that would define the next 3 years of his life. He went outside the firm. This is a significant step. It's not a decision that compliance professionals make lightly. The professional and personal consequences of escalating beyond internal channels, especially in an industry as relationship-dependent as financial services, are real and well understood. Mercer knew what he was risking. He filed a report with the Securities and Exchange Commission through the agency's whistleblower program. And here's where the timeline becomes important in a way that the official narrative never quite managed to address. The SEC's whistleblower program, established under the Dodd-Frank Act, has specific protections built into it. Retaliation against whistleblowers is prohibited. The framework is explicit. The penalties for violation are significant. The documentation requirements for the agency are extensive. And the timeline for initial acknowledgement of a submission is defined. Mercer filed his SEC submission on November 19, 2019. The acknowledgement he received, a standardized confirmation letter, the kind the program sends to every submission, was dated November 26, 2019, 7 days, standard procedure. Everything at that point appeared to be functioning as it should. But then something happened inside the firm that shouldn't have been possible. On December 3, 2019, 14 days after Mercer's SEC submission, which was supposed to be confidential, Mercer was called into a meeting with his direct supervisor and a representative from the firm's Human Resources Department. He was placed on what the firm described as a performance improvement plan. The documentation supporting this plan, which Mercer also retained copies of, cited concerns about his work quality, his communication with colleagues, and what it described as a pattern of misaligned priorities in his professional responsibilities. None of these concerns had been raised before. There was no prior documentation, no previous disciplinary action, no formal feedback of any kind that addressed any of the issues cited in the performance improvement plan. 14 days after he filed a confidential report with a federal regulatory agency, Daniel Mercer was handed documentation that appeared designed to establish grounds for termination. That timing is not a coincidence, and the question of how the firm knew about his SEC submission, when that submission was supposed to be confidential, is a question that was never formally answered. Let's hold that question for a moment because there's something else in this timeline that deserves careful attention. Between November 2019 and February 2020, three other things happened that viewed in isolation might seem unconnected. But viewed together, they form a pattern that is very difficult to explain as coincidence. First, in December 2019, the firm hired a new outside legal counsel firm, one with significant experience in what the legal industry describes as regulatory matter management. This is a specific practice area. It involves, among other things, managing relationships with regulatory agencies during active or potential investigations. The timing of this hire relative to Mercer's SEC submission was never examined. Second, in January 2020, Patricia Orwell, the chief compliance officer who had been in her role since 2016, quietly left the firm. No announcement, no press release. A brief internal memo cited a mutual decision to pursue other opportunities. She has not made any public statements about her departure before or since. Attempts to contact her through professional channels have consistently not resulted in response. Third, in February 2020, the firm underwent what it described publicly as a routine portfolio restructuring. The three portfolios that Mercer had flagged in his original compliance report were, as part of this restructuring, dissolved. The assets were redistributed. The specific portfolio structures that had been the subject of Mercer's analysis ceased to exist as discrete, auditable entities. By the time any external examiner might have wanted to look at those portfolios in the context of Mercer's concerns, there was nothing left to examine in the original form. The portfolios were gone. The chief compliance officer was gone. And the firm had, in place, a legal team specifically experienced in managing regulatory attention. Think about what that sequence of events actually represents. By spring 2020, Mercer's situation had deteriorated significantly. The performance improvement plan had been followed, as these plans typically are, by a formal negative performance review. And in March 2020, in the middle of a global financial crisis that had every regulatory body in the country overwhelmed with emergency response, Daniel Mercer was terminated. The official reason cited was continued failure to meet performance standards. He filed for wrongful termination. He filed a retaliation complaint with the SEC, specifically citing the timeline between his whistleblower submission and the performance improvement plan that followed. And here is where the system failed him in a way that is worth examining very carefully. The SEC's whistleblower program has protections, but those protections exist within a legal and procedural framework that has significant practical limitations. Proving that an employer retaliated specifically because of a confidential submission requires establishing first that the employer knew about the submission, and second, that the adverse employment action was connected to that knowledge. Establishing both of those things, in a legal environment where the employer has significant resources, experienced counsel, and the procedural ability to generate months or years of delay, is extraordinarily difficult for an individual. Mercer had documentation. He had the timestamp on his SEC submission. He had the date of the performance improvement plan. He had the absence of any prior disciplinary record. What he didn't have was evidence of how the firm learned about his submission. That gap, that single missing piece, became the wall that his legal case couldn't get past. His wrongful termination claim was settled out of court in late 2021. The terms were confidential. The firm issued no statement. The case officially was closed. And that, for most people who might have followed it, was the end of the story. But it wasn't. Because here is what wasn't in the settlement. Here is what wasn't in the official record. Here is what nobody who covered this case, and very few did, ever managed to put together. During the discovery phase of Mercer's legal proceedings, a set of internal firm communications was produced. These communications, emails primarily, along with a small number of internal messaging records, were produced in a heavily redacted form. Standard in litigation of this type, the firm's legal team had significant latitude in determining what was responsive to discovery requests and what was subject to attorney-client privilege claims. But within the documents that were produced, within the portions that weren't redacted, there were three specific communications that, when read sequentially, tell a story that the official version of this case never told. The first was an email dated November 21, 2019, 2 days after Mercer's SEC submission. It was sent from an address within the firm's legal department to the firm's chief operating officer. The subject line read, "Regulatory matter, immediate attention required." The body of the email was almost entirely redacted, but the subject line exists. The date exists, the sender and recipient exist, and the phrase "regulatory matter" in the context of a communication sent 2 days after a confidential SEC submission that the firm was not supposed to know about is a detail that should have prompted an immediate question about how that regulatory matter had come to the firm's attention. It didn't. The second communication was an internal message sent by Patricia Orwell on December 1st, 2019, 2 days before Mercer's performance improvement plan was initiated. It was sent to the firm's chief operating officer and to the head of human resources. The message, in the portions not redacted, referenced a need to formalize documentation regarding an unnamed employee's performance record. 2 days before the performance improvement plan, sent by the chief compliance officer, to the head of human resources. The third communication was an email from the firm's newly retained outside legal counsel dated January 15th, 2020, around the time of Orwell's departure, to the firm's general counsel. In the unredacted portion, it referenced resolved exposure in the compliance function and the importance of clean transition documentation. Resolved exposure in the compliance function. That phrase, in the context of everything that preceded it, is not ambiguous. It describes something being neutralized, something being managed, something that had represented a risk being brought under control. That something was Daniel Mercer, and the compliance officer who had either participated in that neutralization or had refused to was Patricia Orwell, whose sudden departure was framed as a mutual decision and who has never spoken publicly about any of it. This is the moment in the story where most people, if they were following it at all, would be expected to ask, why didn't the SEC investigate this more aggressively? It's a reasonable question, and the answer is more complicated than it should be. The SEC's whistleblower program, for all its formal protections, operates within a resource environment that has consistently struggled with case volume. In 2019 alone, the program received over 5,000 whistleblower submissions. The staff assigned to evaluate and investigate those submissions is a fraction of what the volume demands. The vast majority of submissions are reviewed, categorized, and either closed or placed in a queue that can extend for years. Mercer's submission was not, as far as the available record indicates, prioritized. This could be because the submission was assessed as lower priority relative to others in the queue. This could be because the technical complexity of the risk exposure he had documented required analysis resources that weren't immediately available. This could be because the submission was, in the chaos of late 2019 and early 2020, simply buried under the volume. All of those explanations are plausible, all of them might even be true, but there is another possibility, and it's one that the available record does not allow us to rule out. The SEC, like any large regulatory agency, is not a monolith. It is staffed by people, managed by people, and subject to the same institutional dynamics. The same pressures, the same relationships, the same informal networks that exist in every large organization. The financial services industry is not an abstraction to the people who regulate it. It is a specific set of firms, a specific set of individuals, a specific set of relationships. The question of whether Mercer's submission received the attention it deserved, or whether it received something less than that for reasons that had nothing to do with its merits, is a question that the official record does not answer, and the absence of that answer is itself a problem. Let's talk about the portfolios, because that's the part of this case that, in a world where the right questions had been asked at the right time, should have been the central focus. Mercer's original report identified 3 portfolios with what he characterized as systematically misreported risk exposure. He documented this with specific reference to the regulatory disclosure requirements that he believed were being violated. He was experienced enough in financial compliance to understand what he was looking at and careful enough to cross-reference his findings extensively before filing. The portfolios were dissolved in February 2020 as part of a routine restructuring. In March 2020, the global financial markets entered one of the most volatile periods in modern history, The COVID-19 pandemic triggered a market disruption that stress-tested financial institutions in ways that nothing had since 2008. One of the things that market stress events do, one of the things they are supposed to do from a regulatory standpoint, is reveal actual risk exposure. When markets move dramatically, the gap between reported risk and actual risk becomes visible in ways that are very hard to conceal. Here's the detail that most people never connected to Mercer's case. In June 2020, in the wake of the market disruption, the firm in question reported what it described as unexpected exposure losses across several of its investment portfolios. The losses were significant. They required the firm to make a series of disclosures to investors and regulators that it described as precautionary transparency measures. The portfolios involved in those losses were not identical to the three that Mercer had flagged. They had been restructured. The assets had been redistributed. But the type of exposure, the category of risk, the pattern of what had gone wrong, it was consistent with what Mercer had documented in his original 41-page report that was filed in July 2019, ignored for 90 days and then buried. There is no smoking gun here. The restructuring had changed the portfolio structures enough that a direct audit trail from Mercer's original documentation to the 2020 losses would have required exactly the kind of detailed forensic analysis that nobody with the authority to commission it ever commissioned. But the pattern is there, and patterns in investigative work matter. The risk that Mercer identified was real. It manifested. It cost people money. And by the time it became visible, the compliance officer who had flagged it had been terminated. His report had been buried in an administrative miscategorization, and the portfolios themselves had been dissolved. The sequence of events, the filing, the silence, the performance improvement plan, the termination, the restructuring, the dissolution, the losses, that sequence is not a coincidence. It is a system doing what systems sometimes do when a real threat to institutional interest emerges. It managed the threat. And it worked. There's a broader dimension to this case that deserves attention, because Mercer's story is not unique. The structure of what happened to him, the internal report ignored, the external escalation monitored in ways it shouldn't have been, the retaliation dressed up in performance documentation, the legal process dragged until resources were exhausted, the confidential settlement closing the official chapter, that structure is not an invention. It is a documented pattern. Academic research on financial sector whistleblowing has consistently found that the formal protections available to compliance professionals who escalate concerns about their own institutions are, in practice, significantly weaker than the legal frameworks suggest. A 2021 study examining financial sector whistleblower outcomes found that the majority of individuals who filed retaliation complaints under Dodd-Frank protections, meaning they had documented specific cases, did not achieve the remedies the law was designed to provide. The obstacles were not, in most cases, legal in nature. They were procedural. They were resource-based. They were the product of a gap between what the law says on paper and what the system delivers in practice. This is what makes Mercer's case something more than one man's story. Because Daniel Mercer did everything right. He didn't go to the press first. He didn't post anything publicly. He documented carefully. He filed properly. He followed the escalation process. He went to the regulatory body with the specific mandate and the legal framework designed for exactly what he was experiencing. And the system failed him anyway. Not dramatically, not corruptly, or at least not provably so. It failed him quietly, procedurally, in the spaces between the rules, in the gaps between what the framework requires and what the institutions involved are willing to do. That is how systems protect themselves. Not usually through dramatic cover-ups, not usually through obvious corruption, through bureaucratic delay, through resource asymmetry, through the quiet institutional decision to treat compliance concerns as management problems. And Mercer isn't alone. In the years since his case was settled, a small number of financial compliance professionals have spoken, in careful terms, about similar experiences. Not identical, not the same firm, but structurally similar. The report filed, the silence, the performance documentation appearing with suspicious timing, the settlement with confidentiality terms, most of them won't use their names. And that, in itself, is a data point. When the people who are supposed to be the internal check on institutional risk exposure are afraid to speak publicly about their experiences for fear of professional consequence. When the system that is supposed to protect them functions in practice as a mechanism that can be turned against them, then the oversight framework that regulators and the public believe exists is not quite what it appears. This is not a theoretical concern. In the years between 2019 and 2023, there were multiple instances in which significant financial institutions disclosed risk exposure problems that their own compliance functions had reportedly flagged internally before the problems became public. In several of those cases, the internal flagging happened months or years before the disclosure. In several of those cases, the compliance professionals involved are no longer at those institutions. None of those situations were investigated in a way that asked the central question that Mercer's case raises. What happened to the reports? What happened to the people who filed them? And what does it mean for the integrity of the compliance system if the answer to those questions consistently is the reports were managed, the people were removed, and the official record was insufficient to prove otherwise? Daniel Mercer, as of the time this investigation was conducted, is working in a different industry. He left financial services after his case was settled. By accounts of people who know him, he is doing well. He has not spoken publicly about his case. The terms of his settlement prevent him from discussing specifics. But the documentation he retained, the time-stamped compliance report, the internal records, the copies of the communications he received, that documentation is real. It exists. It was examined in the course of litigation. It is part of a legal record. And that record tells a story that the official version, the administrative miscategorization, the performance issues, the routine restructuring, cannot adequately explain. Patricia Orwell, the former chief compliance officer, has not re-entered the financial services industry in a senior compliance role. Her professional profile, as it appears in public databases, reflects her tenure at the firm and ends there. No public statements, no commentary, nothing that would indicate she is a person who had a front-row view of one of the more troubling compliance failures to emerge from that period. The firm continues to operate. It has, since 2020, undergone additional regulatory reviews, standard for institutions that disclosed unexpected losses during the market disruption. Those reviews, as far as the public record indicates, did not surface concerns related to the period or the portfolios covered by Mercer's original report. Which brings us back to where this investigation started. There are cases that end too cleanly. This case ended with a confidential settlement, a dissolved portfolio structure, a compliance officer whose departure was framed as mutual and who has never spoken about what she knew, and a 41-page report that was officially characterized as an administrative miscategorization. Every piece of that conclusion is technically deniable. Nothing here, taken in isolation, constitutes proof of wrongdoing in the criminal sense. The firm's legal team would correctly point out that settlements are not admissions of liability. That portfolio restructurings happen for legitimate business reasons. That administrative errors in document management systems do occur. That performance improvement plans are sometimes legitimately initiated for the reasons stated. All of that is true. But what is also true is this. A compliance officer identified what he believed to be a serious regulatory disclosure failure. He followed every proper channel available to him. The institutional response to his report was not to investigate it, it was to manage him. The portfolios he had flagged were dissolved before they could be independently examined in the form he had analyzed. The regulatory submission he filed was confidential, and yet the firm's response to it began within days. The losses that occurred in 2020 were consistent with the risk categories he had documented. And the case is closed, not because it was resolved, but because the system ran out the clock. This matters beyond Mercer's case, because if the compliance framework that the financial system relies on, the internal reporting structure, the regulatory whistleblower protections, the legal mechanisms designed to surface problems before they become crises, if that framework can be systematically neutralized by the institutions it's designed to police, then the oversight architecture that regulators and investors and the public believe is functioning differently than advertised. The 2008 financial crisis was not primarily a failure of individual bad actors. It was a failure of systems that were supposed to catch exactly the kind of risk accumulation that produced the crisis and didn't. The post-crisis reforms were designed to strengthen those systems, to make them harder to circumvent. What Mercer's case suggests, and what the pattern of similar cases suggests, is that the circumvention didn't end. It adapted. It became procedural instead of obvious. It learned to use the language of compliance to manage the people doing compliance. And that adaptation has never been formally examined. Not by regulators who have the authority to look. Not by legislators who have the power to ask. Not by the press in any sustained way. The question of what happens to the reports that are supposed to protect the financial system, where they go, whether they're investigated, what happens to the people who file them, that question remains unanswered in any systematic way. And that might be the most important thing about this case. Not the specific portfolios, not the specific firm, not even what happened to Daniel Mercer. The most important thing is what his case reveals about the mechanism, about the gap between the system that exists on paper and the system that operates in practice, about who benefits from that gap remaining unexamined. There is one more detail from this investigation that hasn't been addressed. In the discovery materials from Mercer's litigation, in the documents that were produced, in the records that were disclosed, there is a reference to a communication that was never produced. A gap in the email record. A period of approximately 3 days in late November 2019, the days immediately following Mercer's SEC submission, during which the firm's internal communication record for a specific set of participants is either missing or was not responsive to the discovery request. The firm's legal team characterized this as a technical records retention issue. The litigation focused on the specific claims Mercer had brought did not drill into that gap. But those 3 days, the 3 days immediately after a confidential regulatory submission, before the internal legal communication flagging a regulatory matter before the performance improvement plan was initiated, those 3 days are the part of this story that nobody has ever explained. They may be nothing. They may be exactly what the firm described, a technical records issue. But if there's something else, if those 3 days contain the communication that explains how the firm knew what it shouldn't have known, the communication that connects the confidential submission to the institutional response, then the picture this case presents is not just a compliance failure. It is something considerably more serious. And we may never know, because that's how these things work. The gaps are always just plausible enough to dismiss. The timing is always just coincidental enough to explain. The documentation is always just incomplete enough to prevent the conclusion that the evidence otherwise suggests. That's not an accident. That's architecture. Daniel Mercer filed a report because he believed the system required it, because the rules said it was the right thing to do, because he trusted to some degree that the framework existed for a reason. He was right about all of that. He was also wrong about something more important, that the framework, when tested, would function. It didn't. Not for him. And based on everything that has emerged from cases like his, similar cases, similar patterns, similar outcomes. Not for the people who came before him, and almost certainly not for the people who have come after. The system that is supposed to catch these things is the same system that is supposed to protect the people who catch them. And in the space between what that sentence means and what the record shows actually happens, in that space, is where the truth that nobody wanted you to see has been quietly living for a very long time. The case of Daniel Mercer is officially closed. The portfolios are dissolved. The settlement is confidential. The firm continues. The compliance officer who may have known the most about what happened has nothing to say. The regulatory record is incomplete in ways that can be explained or ignored. And somewhere in a document management system, logged under a classification code that routes it outside the standard review process, is a 41-page report that was never investigated. Filed July 14th, 2019, still there. Still unresolved. The real question isn't what happened in this case. The real question is how many reports like it are still sitting in systems like that one. How many compliance officers filed carefully, documented rigorously, followed every proper channel, and then watched the system they trusted use those same channels against them? How many cases ended the way this one ended? Quietly, procedurally, in a way that can always be explained and never quite disproven. How many times has the gap between the framework and the function been used to protect exactly what the framework was designed to expose? Because if this happened once, if the pattern here is real and the evidence suggests it is, then it didn't happen only once. It happened in the way that institutional failures always happen, systematically, quietly, with just enough plausibility to survive scrutiny. And that pattern may be the most dangerous thing that nobody officially is looking at. The investigation isn't over. It's just beginning.